Thank you all for joining us. We'll go ahead and get started in just a minute. Okay, we will go ahead and get started. Good evening, everyone, and thank you very much for joining us. My name is Mariela Colon, and I'm a librarian with the Civic, Cultural, and Literary Engagement Department at the Chicago Public Library. Tonight's virtual event is part of our Law at the Library series in partnership with Evanston Public Library and the Chicago Bar Association. We continue to be grateful to CBE for their continued support for this public information series. During tonight's program, we will be monitoring an online chat from the audience for Q&A following the conversation. Please use the Q&A button at the bottom of your screens to enter your questions, and we will get to them at the conclusion while time allows. So at that point, I'm pleased to introduce our speaker for the evening. Tonight's speaker is Carrie R. Peck, attorney, managing partner of Peck Ritchie LLC Attorneys at Law. He is the past president of the Chicago Bar Association, and his clients have included families, hospitals, banks, the state of Illinois, County of Cook, and City of Chicago. We will begin the program. And again, if you have any questions, please put them in the Q&A button at the bottom of the screen. And with that, I will pass the baton to Gary.
Okay, thank you very much for the kind introduction. Good evening, ladies and gentlemen. Welcome to the Chicago Bar Association Law at the Library events. As you know, my name is Carrie Peck, and tonight we're going to talk about why you should plan ahead, wills, trusts, and estate planning. Next slide, please. There we go. Okay. So we're going to start our presentation with a hypothetical, which unfortunately is all too real. And I think when you see this and hear this hypothetical, you'll understand why we're talking about it. James is a successful businessman with a growing company by the age of 30. Mia, James' girlfriend, has been by his side since they were teenagers, helped him get his business off the ground. While the two have never been married, they do have a 3-year-old daughter, Emily, and recently purchased their first home together. James and Mia have always lived in the here and now, and with getting the business off the ground, never focused much on planning for the future. Besides, they were both so young and barely had any money until the recent success of the business. Next slide, please. One evening, the unthinkable happens. James was riding his motorcycle home from work and was involved in an accident with a distracted driver. The driver of the vehicle that hit James walked away uninjured, but unfortunately, James passed away at the scene. Mia and James' families are devastated at his untimely passing. He was still so young, had so much life to live, a business to keep growing, and a family to support. How could this happen to them? Prior to his passing, James had not gotten around to completing an estate plan. He always wanted to make sure me and Emily were taken care of, but getting it done always ended up on the back burner. He thought the money to pay for planning would be better put to the use in growing the business, fixing up the new house, etc. Mia, the girlfriend, hires a probate attorney to begin settling James' estate when she finds out that his parents have already begun the process, seeking to administer his estate themselves. Now, you might be waiting until it's too late. We're going to talk about James in a moment further, but the question is, what would motivate you to do estate planning? Well, the largest number of people, about 41%, said a medical diagnosis or health concern. Approximately 16% said the death of a loved one, 20% said expansion of a family, 22% said a purchase of a home, 21% said retirement, 14% said if it's an employer benefit, and a full 24% said nothing would motivate me to do estate planning. Well, maybe this following discussion will. Next slide. So, what is estate planning? Estate planning is the distribution of estate assets upon death. It's the advanced planning for the management of your financial affairs in case of mental incapacity. It's advanced planning for healthcare decision making, and it's the avoidance of probate. Probate is a post-death court proceeding required in Illinois if an individual dies with assets greater than $100,000 in their name alone. And I'm going to say again, in their name alone, not joint tenancy. Joint tenancy, A and B own a piece of property, and A dies, it goes to B. Many retirement accounts say Carrie Peck, IRA for the benefit of or payable on death to my wife. That avoids probate. And estate planning can also include asset protection. Next slide, please. So what's the goal of estate planning? Well, even before the estate taxes, the goal of estate planning is to protect assets from creditors, to preserve family wealth for future generations, to provide for support and income flow to the family under all circumstances, to manage assets for themselves, for those who cannot, and business succession planning. Now, I want to focus for a moment on going back to our hypothetical. At the end of the day, the longtime girlfriend, the mother of the decedent's child, ends up with nothing. Why? Because her longtime boyfriend had no estate plan. The parents and the child will end up with assets, but the girlfriend who devoted her life to her boyfriend, the success of the business, gets nothing. Now that's a horrible result, and he could have changed it by doing an estate plan. Next slide. So what can I expect from an estate plan? Well, in generally a small estate, we focus on who and how your assets will be managed during your lifetime if you become unable to manage, under what circumstances it may make sense to distribute your assets during your lifetime, or should they wait until post-death, and how and why your personal care and healthcare decisions will be made during your lifetime if, for example, you have a stroke, a heart attack, and you can't manage those things for yourself, how and to whom your assets will be distributed after your death, and who will be guardian of your minor children should you become unable to do so and help your children and be their parent, so to speak. A large estate addresses various ways of preserving estate assets and tax planning. In Illinois, for example, we have an Illinois inheritance tax for an individual who dies with assets in excess of $4 million. So tax planning is important. Next slide, please. So some of you may remember the Doublemint twins. Doublemint was a gum, and these folks, the Doublemint twins, did commercials on TV. And why are we talking about it now? Because under the term power of attorney is a document in which you grant an agent to make decisions for you, generally when you're not capable of making them yourself. So a legal document granting authority to someone else, your agent, whom you trust to act for you in certain circumstances. So it's your legal clone, like the Doublemint twins virtually the same kind of situation. Next slide. Please remember, power of attorney documents are exclusively valid during your lifetime. They die when you die. In Illinois, we have two types of powers of attorney: a power of attorney for property, and we'll talk about in a minute, a power of attorney for health care. So, power of attorney for property, don't be confused, it's not only real estate, it's everything that you own, your money, your house, perhaps real estate. If you own any stocks, if you own any CDs, this is a generic term, property. So why do we want to name an agent to make decisions for us should we become incapacitated? And the reason is we avoid a lifetime probate. You recall a few slides back, I talked about a post-death probate. If you become incapacitated in Illinois and you do not have powers of attorney for property and or health care, the law requires that we go in and ask the court to appoint a guardian to make decisions for you in the management of your assets and the management of your health care. So that's a lifetime probate proceeding. In Cook County, the entire 18th floor of the Daley Center are probate judges, approximately half of them hear post-death cases, and approximately half of them hear lifetime guardianship cases. So, power of attorney for property, again, management of your assets. It's especially helpful for assets that cannot be owned jointly. Again, joint property is A and B. A dies, it goes to B and avoids probate. But assets that can't be owned jointly, health savings account, IRAs, retirement accounts, and property certainly not put into trust, we can use a power of attorney for property. Additional powers that would be used in conjunction with a power of attorney for property: income taxes, tax activities, signing and filing tax returns. Should you become disabled, subject to court approval, you can actually do estate planning, establish Medicaid planning, change the title to property, and gain access to medical information, which we'll talk about in conjunction with a power of attorney for property. In Illinois, we call these documents durable powers of attorney because the term durable means they continue when you're no longer competent. You no longer have the capacity to make decisions, and the property power and the healthcare power allow an individual to make those decisions for you without court involvement. Next slide, please. So this is the second type of power of attorney. Again, a durable power of attorney because it remains in effect when you're no longer able to make your own decisions. Much like the prior discussion, you name an agent who you trust that you're going to rely on to make the right decisions for you when you're not able to be consulted regarding those decisions. So that agent is going to make, in this instance, your health care decisions. And those health care decisions include end-of-life decisions. The statutory durable power of attorney for health care will require you to determine and in writing, make a decision granting your agent authority to take into account the quality of your life, okay, or the quantity of your life. Do you want to remain alive no matter what the diagnosis is? Or do you want the quality of your life to be taken into account and moved up the chain for your agent to make decisions? So quality over quantity is very, very important. We call that an end-of-life decision. Also, we want to know when you want your power of attorney for both healthcare and property to become effective. Should it become effective immediately upon signing? And then should you get in an auto accident or have a stroke or be unable to make decisions, bingo, it's effective. Or do you want your power of attorney to be effective only when a doctor determines that you're no longer capable of making your own decisions? So the healthcare power gives your agent general directives. Your agent will decide ultimately, based upon your stated intentions, what to do in each case. And a healthcare power of attorney is also very, very important in terms of getting medical records, medical information. Everybody, I think, heard these days of HIPAA, HIPPA, which prevents individuals from getting access to medical information unless they have a power of attorney for healthcare or their court-appointed guardian. So HIPAA is really important if you want your family to make decisions. Generally, you're going to have to give them a power of attorney for healthcare. In some instances, spouses are allowed information, but the best method is name your spouse agent so that they can overcome the HIPAA prohibitions to get access to medical information. Next slide, please. So everybody's probably heard of a will. And of course, the will, formal name is last will and testament. Now, unlike the two documents, power of attorney for healthcare and power of attorney for property, that we just discussed, those are lifetime documents. Again, they die when you die. A will has no validity at all until you pass away. None whatsoever. We get clients all the time that say, I'm the executor of Carrie's will, and I want to do the following, and I should get access to medical records, and I should get access to money, and I should be able to make decisions. Well, ladies and gentlemen, an executor during lifetime named in a will has zero power, zero ability to do anything. This document is only effective post-death, and it's generally only effective when an executor, that's the person that's going to manage your assets after you die, is appointed by the probate court to be the executor. So that executor is going to manage your assets, pay your debts, and distribute them to the beneficiaries you name. So I name beneficiaries in my will. I name my family. I name my friends if I wish. I name charities if I wish. It's entirely up to the individual that when the will is done to name the beneficiaries of their assets and an executor. Please don't attempt to do this online. It's likely to be a disaster. You'll be gone and you won't know what a disaster you've left behind. A will does not avoid probate, okay? A will, if the assets are, again, in excess of $100,000 in your name alone, it will not avoid probate. Again, probate is that court proceeding post-death, administering your assets, paying your debts, subject to court supervision and court decision-making. Next slide, please. So the next slide is what we call a revocable living trust. And a revocable living trust, the concept is we want to avoid probate. We use this to avoid probate. And how do we do it? A revocable living trust is created, and we change the title of our assets to the revocable living trust. So my trust says Carrie Peck, trustee, we name ourselves trustee of the Carrie Peck Revocable Living Trust dated June 18th, 2025. Again, why do we do this? To avoid probate. In all 50 states in the country, a revocable living trust, if drafted appropriately and funded appropriately, the term funded means assets are title changed and put into the trust. So you call your bank and you say, I have a CD and I want to change it and put it in my trust, or I have a brokerage account and I want to change it and put it into my trust. And banks, brokers, etc., are very now attuned to getting this done with a limited amount of hassle. But it avoids the post-death probate, the cost of doing it, and the delay. A post-death probate must be open not less than 6 months because the law provides creditors, okay? Those could be doctors, could be credit cards, could be funerals, could be hospitals, are entitled to file claims against your estate in probate, and they must file within 6 months. Most probate estates are open probably a year plus post-death. Many scenarios prevent distributions of assets post-death to the family. So that's something you want to avoid if you can. Use of a revocable living trust does so. It's a private document. It can be amended during your lifetime as long as you have capacity. It avoids lifetime guardianship. It allows for estate tax planning. There is no asset protection planning for the individual that we call the grantor. That's the person creating the trust. It provides a mechanism to manage assets for beneficiaries, and for them can provide certain creditor protection. It's an integral part of an estate plan. Now, typically, if you're going to use a revocable living trust, you have 4 documents in your estate plan: a revocable living trust, a will, which is what we lawyers call a pour-over will. What does that mean? It means if you have assets in your name alone, you pour over into the trust. And if they're below that 100,000 threshold, we avoid that probate. At the end of the day, what we really want to do is get all of your assets, except your retirement accounts generally, into the revocable living trust. We can retitle real estate as well and put it into the revocable living trust. So those 4 documents are a trust document, a will, a durable power of attorney for healthcare, and a durable power of attorney for property. Basically, 4 estate planning documents. Many people do only 3 powers of attorney and a will, and don't use a living trust. Next slide, please. So we have also the ability to create an irrevocable trust. This is often used to facilitate gifts to children or minors or some individuals that require asset protection, building a wall between the money and the creditors. And the person creating the trust, the grantor, cannot make changes to the trust. And most complex estate tax reduction strategies incorporate irrevocable trust. And irrevocable means what it says. You can't change it once it's signed. Unlike the prior slide, a revocable living trust, we can amend it until you're not competent or until you die. An irrevocable trust cannot be amended after it's signed and created. Next slide, please. So we've talked about it, but here's, kind of the written so you can see it. What is probate? Probate is a court-supervised process by which the representative, generally the executor, if no will, an administrator, is appointed to collect a deceased person's assets, pay their debts, and distribute the balance to those entitled to receive. Under a will, you decide who gets it. Under a scenario where we started with our hypothetical, the Illinois General Assembly, the Illinois legislature has decided who gets it because there's a chart. Who gets what's called intestate, dying without a will, what percentage? Go back to our hypothetical. Mia gets zip, the child gets approximately half, and the parents get approximately half. So probate law is governed primarily by state law and secondarily by the local county procedure. County procedures generally differ a little bit from county to county. Cook, Lake, McHenry, Kane, etc., DuPage. My law firm practices in all those counties, so we know what those procedures are. The persons entitled to receive the estate are those identified in the decedent's last valid will. Okay. What makes it invalid? Well, an individual lacked capacity to do it, or they were unduly influenced by somebody who persuaded them generally to give the assets to them, an undue influencer. Then we talked about already the state's intestate succession laws. That's if someone dies without a will. Probate law is primarily a statutory law scheme that lays out the groundwork for the procedure of settling the decedent's estate. Again, post-death estate. Next slide, please. So, probate court is the forum for estate issues. Most estates run smoothly and often can be completed and closed without issue. However, when family members or beneficiaries do not get along, or the estate plan was not crafted properly, complications arise. I've never, in over 40 years of practice, seen an estate go smoothly or a will scenario go smoothly when people do it by themselves. Yes, there are forms online. Yes, you can go to the store perhaps and buy forms. It will be the biggest mistake you ever made in your life because you leave your family and friends with a big headache. It costs a lot of money to administer and costs a lot of money potentially to solve the problems if you can. Next slide, please. So what are the potential estate complications? Well, a will validity challenge. For example, the will was not properly executed. What do I mean? Illinois requires 2 disinterested witnesses. Sometimes we see a will signed by the person that died and was witnessed by the person's family. Well, that's going down the tubes, ladies and gentlemen. Witness must be disinterested. A will contest, when there's issues of fraud, forgery, capacity, or undue influence surrounding the execution of the will. So hypothetically, John Doe is in stage 4 of Alzheimer's disease, and his girlfriend takes him to a lawyer, and he signs the will, and the will cuts out his children. The children would have a viable will contest asserting that dad lacked capacity and was unduly influenced by the girlfriend, who probably had the will written to leave her all of the assets, cutting out the children. Will construction is another estate complication when the terms of the will are ambiguous. Okay. Perhaps there are more people with similar names. Perhaps the charity is not properly identified, things of that nature. Or perhaps it says, I leave these assets to my daughter. And the man doesn't have a daughter. He has somebody he used to call a daughter. Heirship disputes, when the identity of the decedent's heirs is disputed. Okay. What does that mean? When an individual has a child out of wedlock, and we need to demonstrate perhaps that on one side the child is a child of the decedent, and on the other you've got family generally trying to disprove that that individual is a child of the decedent. Contested claims, creditors file claims that are disputed or contested. You don't believe that the doctor or the hospital should be paid the full amount they filed for. You believe the hospital bill, instead of being $10,000, should have been $2,000. That's an example of disputed. Citations to discover or recover, when somebody refuses to turn over assets that properly belong to the estate. Maybe an individual believes that that money or the asset, the house, the car, belongs to them, doesn't belong to the decedent. We issue what's called a citation to discover and or recover to bring that asset back into the estate. Breach of fiduciary duty when the representative acts improperly. So whether it's an executor appointed under a will, or whether it's an administrator because the individual died without a will, both of them requiring court appointment, the executor or the administrator steals assets from the estate. That's a breach of fiduciary duty. Need to go into court, ask the executor or administrator be removed, the money be returned, and if they don't have it, perhaps they own a house, you try and take their house. Accountings, fee objections, when the accounting of the estate activity is objected to, an executor administrator has to account for the money. How much did we have when we started? How much did we spend on expenses, maybe claims? How much did we spend to open the estate? Money goes to the clerk of the court. How much money do we spend on legal fees for the lawyers that did the work managing the estate, opening the probate estate? And what are the fees? And are those fees going to be agreed to or contested? Beneficiaries are entitled to an accounting of an estate. So again, the representative, the executor administrator, will be required to produce an accounting. That accounting says from JP Morgan, from Citibank, we took in X number of dollars. From a retirement account, we took in X number of dollars. We have a car, we have a house, we have a boat, we have a vacation house. All of these are valued at X number of dollars. And then less the expenses, again, less the fees, that's an accounting. Next slide, please. So now we're going to talk about examples of probate and non-probate. Elvis died and he had about a $10 million estate. He lost about 73% of that estate in the probate process to settlement costs, estate planning. And his case illustrates why a trust is often the best way to protect an asset in the estates. Had he used a trust, he could have avoided the delays and probably a fair amount of the expenses. So let's go to the next slide, please. So how to avoid probate? We've talked about it generically. Joint tenancy with right of survivorship, more often than not used exclusively for real estate. Carrie owns a house. He's A. Carrie owns a house with his child. She's B. Carrie dies, the house goes to the child and avoids probate. But it can cause some difficulty as well. And it really only postpones probate until generally it's a husband and wife owns it. Husband dies first. Sorry, fellas, we seem to die before our wives. House goes to the wife. She doesn't change the title. That house then goes into probate. It's difficult to remove the co-owner of a joint tenancy and potentially exposes the assets to the debt of other individuals. A has no debt, B does. B's creditors come in. And it also may unintentionally disinherit your heirs. If you want your children to share in the proceeds of the sale of the house, then don't put it in joint tenancy, because the joint tenant gets the property free and clear and does not have to share it with your children or other beneficiaries. Use of a trust, revocable living trust, we've talked about earlier, that avoids probate. Next slide, please. So now we're going to talk about some people that perhaps you've heard of, some people you haven't, what we call in this segment the mistakes of the rich and famous. So there's an actor by the name of Chadwick Boseman. He's probably best known for his role as Jackie Robinson, James Brown in Get On Up, and Marvel's Black Panther. I think, frankly, that's the one I know him from. And he died in 2020 at the age of 43 of colon cancer. No estate planning of any kind. His wife petitioned the court to split his estate evenly with his parents. Now, don't forget, had he done a will, he could have left his wife 100% of the estate. He could have also left his wife 80% or 70% and given his parents 20%, 10%, whatever he wanted, but he died without a will, and his wife got 50%, his parents got 50%, and 1/3 of the estate was lost to costs, fees, funeral, burial, court expenses, legal fees, taxes, etc. Okay? A tragedy that he died early and a tragedy that he didn't do any planning. Next slide. Heath Ledger, I think best known for The Dark Knight. He died in 2008 at the age of 28, accidental overdose of prescription meds. His will was executed in 2003, with 50% of his estate going to his siblings and 50% to his parents. His daughter Matilda was born in 2005. She was not included in the will. Now, thankfully, his parents and his siblings voluntarily gifted money to his daughter. Another ridiculous situation that could have been avoided. Why? He had to amend his will. He had to do a new will. He had an amendment to a will is called a codicil. He could have done a will after his daughter was born. Next slide. Amy Winehouse, a pretty troubled British soul singer. She dies at the age of 27, alcohol poisoning. Unmarried without a will, so her estate went to her parents. 2019, her ex-husband of 2 years files a claim saying he was entitled to money because he was married to her at the time of her success. He'd previously been awarded a cash settlement at the time of their divorce. I don't think he got anything. Next slide. Sonny Bono, I think everybody knew Sonny as the husband of Cher. He died in 1998 of a skiing accident, and he left behind a wife and 4 children. He had approximately $2 million. Sonny had no estate planning. His fourth wife, Mary, petitioned to be appointed executor. Cher, his famous wife, filed a lawsuit against the estate for $1.6 million, asserting he'd never paid her since their divorce. Another man files a lawsuit claiming to be Sonny Bono's love child before dropping the case when he was asked to provide DNA. Eventually, the case is settled between his wife, fourth wife, and his children. Next slide. James Gandolfini, best known, of course, for The Sopranos. At the ripe old age of 51, he dies of a heart attack with an estimated estate worth $70 million. $70 million, okay? His will left about 80% of his estate exposed to taxes. He had to pay, his family had to pay $30 million in estate taxes. Why? No planning. No proper planning. He had a will, but no proper tax planning. Next case, please. So let's address the obvious. None of us want to talk about death. None of us think we're ever going to die. It's not a comfortable conversation. However, it is essential. I can't emphasize how important it is. If you want to save your loved ones added frustration, heartache, and cost after you die, don't do an estate plan. But you should do an estate plan to make it as simple as you can. It's never entirely simple, but you reduce a lot of aggravation. Getting your proper documents done correctly, have them organized, will help you and give your family peace of mind. And very, very important, tell somebody where you keep your documents. I've had more than a few cases in which the family comes in and swears Dad did a will. Well, where is it, folks? We can't find it. Well, guess what? If you can't find the will And I mean the original signature bearing will, not a photocopy, not an email copy, the original will, it's presumed to be revoked in Illinois. Presumed to be revoked without the original wet, so to speak, ink signature. So critical. Tell somebody it's going to live longer than you where it is. Next slide, please. So what are key takeaways tonight? You don't have to be rich or famous to need proper estate planning. No matter the size of the estate, proper planning is important. Mistakes can turn into costly and potentially public process. And as we take a look, kind of the overview of an estate planning review, does your will or trust match your wishes? Are your assets titled correctly? Are they in the trust? Are they in joint tenancy? How are they titled? If you created a trust, I used the term earlier, have you funded it? Meaning, have you changed the title on your assets and put it into your trust to avoid probate? Again, in Illinois, if you die with assets in excess greater than 100,000 in your name alone, the law requires we open a probate estate. And finally, are you still comfortable with the agent, the clone, the double and twin clone that you named under your power of attorney for healthcare to make healthcare medical decisions and end of life decisions? And are you still comfortable with the agent you named to make property decisions? Again, not just real estate, asset decisions, asset management decisions. Are you comfortable with that individual? Or have you had a falling out? Or you don't even know where they are, or they died. Life changes, folks. It's incumbent upon you to stay on top of the changes that may impact your estate plan and may impact on when your family gets it or when your family doesn't get it. And these are really, really important decisions. Next slide, please. So we at Peck Ritchie offer you the opportunity to meet with us either in person, by Zoom, similar to what we're going through now, by telephone in a free initial consultation. We use what we call a concierge approach. As was mentioned at the top of the hour, we are recognized leaders in elder law. I serve as chair of the Illinois Supreme Court first ever Elder Law Commission. I lecture on these subjects around the country. We are the only law firm in Illinois that is a legal education partner for the Alzheimer's Association. The American Bar Association asked me to write several books in conjunction with the Alzheimer's Association. I was engaged some years ago by Mayor Daley to rewrite the State of Illinois Elder Abuse and Neglect Act. And next Wednesday, if you'd like to turn on WGN at 11:30, I do a monthly radio show for WGN where we answer questions in the arena that we've talked about tonight. So thank you for joining us, and I'll turn the floor back to our hostess so that we can answer some of your questions.
Thank you so much for that comprehensive 101. I'm going to go ahead and relay some questions from the audience. And just a reminder to everyone, you can go ahead and click the Q&A button at the bottom of your screens so that we would get them for him to address.